bit kache hotna ilo mane paramo piru yeno ben.
That briefly gives the context within which this trial. And having said that, I'll just Duncan the Swagger give a procedural history.
Again,
I've gone live. Trial.
Mana yetchen lock ma wero watika winyo piru man dana bilego ngon ko badit Duncan the Swagger me wa ma piru man chaka kere the work kere.
Thank you, my lord. I'm going to give you a brief procedural history of the case.
Abin wiye ketma piru man chaka kere lokma o kere nyim ko piru.
The accused, Thomas Kwoyelo, was captured by the Uganda People's Defense Force back in December in the Democratic Republic of Congo on 3rd March 2000.
Koroti Ikomeni, Thomas Kwoyelo, Lumonpa UPDF, na Lumonme Uganda, Umarai Garamba, in the death Mudima, death, Morali Kamen, Congo.
He was subsequently brought back to Uganda and detained at the prison Luzira.
Kere Edware Uganda Kang, Chipi Ware Ganguch, Madit Matil Luzira.
On 12th January 2010, while in detention, he made a declaration before the officer in charge of the prison that he was renouncing rebellion and seeking amnesty.
Neondwe Aparario, Midimatel, Morali Bario Kampa, and Wanyim Ngadmatika Tinchkuno, and
the declaration was submitted to the Amnesty Commission.
Can lega mamega kilo mamega ni bot dulma nero check na temukija in Uganda kan.
On 19th March 2010, the Amnesty Commission forwarded the accused's application to the DPP, Director of Public Prosecutions, for consideration in accordance with the provisions of the Amnesty Act.
In the pa we abung wen mi duma dek makali bari o kapa dulman uchwalo lokpa na Uganda.
Nevertheless, on 6 September 2010, the DPP referred to criminal charges against the accused before the Chief Magistrate's Court at Uganda Road Court in Kampala.
Kerebet kumeno ni rabichiel mi duma abung wen makali o kapa office pa lukara dot medit me Uganda umoro dot com gama dot komeni I court me magistrate natie Uganda Road I Kampala.
The accused was subsequently committed to the ICD, National Crime Division, the High Court.
The Kobo lock Nadma dot komeni but courtman na ICD courtman now Bal Nebulo Madon, ma High Court in Uganda.
To face 50 charges.
Unke wanyini anno tiki adopt therapy come mamira en gam loye.
He lodged a constitutional petition.
U twalo ko I court madit ma nano
that was constitutional petition number 36 of 2011.
Nama court ma ano you can remember ko ne court me constitution yo pero number that habitual no wala to kapara.
Three questions were raised in the petition of reference. On the 22nd of September 2011, the Constitutional Court held the accused's reference, holding that although the Amnesty Act did not offend Uganda's international treaty obligations, nor did it take away the prosecutorial powers of the DPP given under the Constitution, as submitted by the accused, had been discriminated against contrary to the provisions of Article 21, Sub-Article 1 of the Constitution of Uganda.
In the Peru, we are real, Midema, Bungwen, Magalere, okay, apa, Constitution, or Jolo, Lock Paladiti, Conwagani, Repeti, check me, Timu, in a poke when you were DPP, me Piru, and a power, Unen, Icom, Mother, take company, and auto. Check Uganda, Peru, check to check Peru, check Uganda.
The Constitutional Court made an order for the file to be returned to the International Crime Division with the direction that the court must seize the accused's trial forthwith.
Court me namlo tema penso chukere umiaro cha nikidwa lokman nyim court me jok piru wa iko badot komi.
The Attorney General appealed to the Supreme Court, appeal number 1 of 2012.
Ma uberu na achiel ma arivario tapario.
The Constitutional Court delivered its decision on the 8th of April 2015.
Court me ditu umio wal mege in the rapport me me ngwen ma arivario tapara beach.
Specifically, the Constitutional Court said that the Amnesty Act does not impinge on the prosecutorial powers of the DPP and is not inconsistent with the Constitution in that regard.
Court ngoro ni chik mete mukijani pe kwanyo twero pa office pa lokala dot wago dok bene pe otoro chik mokeken.
The accused was then arraigned before the International Crimes Division of the High Court, and the indictment was read to the accused again on the 14th of March 2017.
Iman ki ikelo ngama doti komeni inyim court me ICD chike kwano kogomati kome nyendo pavia when me de mate moral vario kapara bero.
On 25th January 2017, of counts for which the accused stands trial to 93 counts.
In the period of pitch me de machel moral vario kapara bero. Office pa lokala dot go Lago adot ma iti ke more kom ma dot komeni o well adot ma ti komen uchero malo e piera buen mia dek.
These included several charges based on international criminal law,
Iki adot mogo ma toro check me palme wilogo
with domestic charges in the alternative.
kun ki karu bene adot ma toro check me Uganda ikingere.
The international criminal charges consisted of crimes against humanity, murder, enslavement, rape, torture, imprisonment, and other inhuman acts.
Bal ma ke doro eni ye uber bal mogo ma no tore kom dano ma chalo ne bawon ke bal mukan na madon.
The indictment further in a cumulative manner included international criminal charges that are serious violations of Common Article 3 of the Geneva Conventions applicable to the internal armed conflict.
Bal ma ke doro ye angama doti kom bene utoro check tiyo ke check ma neno dul me ate me check me Geneva.
The Common Article 3 charges in the indictment included murder, hostage taking, cruel treatment, outrages upon personal dignity, violence, life, and the person as cruel treatment and torture.
Ite check na ma dek me check me Geneva ma ke doro perenga ma doti komeni ti kine bal me net ma kutano la boy fuero rani ti mo timogo ma nano deo padano awon I gero.
The DPP also included some counts which were based on the Penal Code Act.
Office pa lokala dot bene umera dot mogo ma toro check me Uganda.
The matter was brought before the court for pre-trial.
Ikero no man him court but jack you piru ye.
On the 30th of August 2018, the pre-trial judge found that the prosecution had established sufficient evidence, established substantial grounds to believe that Thomas Kwoyelo was responsible for the charges.
In Andre Pierre de Jama Boro court ma chago winyo piru unoni Thomas Kwoyelo mero gamlok ma ke Maria de Komeni chigumo ni adot magamer chunim court.
On 12th November 2018, the trial against the accused commenced in the High Court of Uganda sitting at Baruli.
In the pario me de me apave chil ko para boro winyo piru uchake High Court me Uganda ma berga temeki gulu.
The prosecution presented 53 witnesses.
Lo kera dot gumio saden mamege nyim court kun saden pier bitu de gumio lo nyim court.
And on the 18th of December 2023, the trial panel found that the accused person has to answer in respect of 78 counts out of the 93 counts that had been preferred.
In the power we are born with the apa makan bagi okay pier we that ngol ko puno ni ngamat dot community lok me gama kom adot pier pier we are born ikom pier mwen we that mano tomorrow adot recommend.
On the 15th, the defense of the accused person commenced.
Donc, comme dot uchake in the parabit with the man when makan bagi okay pier when.
The defense presented a total of 4 witnesses.
Lo piama dot gum kelo chaden angwen ne dok lok ma dok dot mati kom
Included the accused himself.
ikine chaden wen den tenga ma dot kom.
And the hearing of the defense closed on the 8th of May 2024.
We knew lok pa lo piama dot kilor ne be boro mi de ma ma aman.
With that brief procedural history, I would now like to invite my brother, Brother Justice Mobiru, to deal with some preliminary objections that were raised by the defense.
We ket malok man chakek pare o kere yim kot eno dalego la dinga kop medit seven Mobiru med dok kon kwe pa lo piama dot mogo mago bere kwe na yim kot kan.
Thank you, my lord. The judgment is divided into 13 segments, and the segment on
ke poko kin ngol lokman ke kene apar.
in this part of the judgment, we dealt with 3 points of law raised by the defense, and 3 that we found necessary to address because they were jurisdictional.
Dare kom nagade ma dor ke ma check tiu kwere ma lu ke ma dor yo ati kwere ke bene wa neno nagade mo kene wa matamu ni wate e log material kot kan.
The first point raised by the defense was a challenge to the principle of legality raised in respect of multiple counts of offenses against the money.
Log ma chel ma kwe me chel ma no ke tiu ki ador na pat ma ikom ador chel ma no ke ramot rebune wago.
That issue was dealt with at the pre-trial stage and also at the case to answer stage of the case.
Lokman ke dog ye karma put ki chaka winyo piru chaka ke bene karma tika dog ikom lok ni ngatma dot ikom tika lok me kama.
Nevertheless, we visited it and came to the same conclusion, but with some additional justification overruling it.
Wa dog ye ti wa mero lok mo ma teno ye kun wa kwero pe man wa.
So the trial does not violate any of the principles of legality.
Peman when you piru man pe toro check mo ke ken.
The second point raised by the defense was the challenge to the joinder of charges, principle and alternative.
Lok ma rio ma lo ke ma dor category any ribo dot.
Again, we reviewed the law and practice of courts and came to the conclusion that the objection was unfounded and overruled it.
Wa dog wa ngiyo te book ma na lo check to no ni kwe ene uno petiu ki wa kwero le ko.
The third objection was a challenge to the cumulative nature of the charges.
When I bet my look at the query, and I do a dot, mark it Dora.
The argument being that the accused is facing multiple offenses arising out of the same conduct.
Ruwado ni ngama dot community kimora dot mapol i community gina chiel mano eno tengo nyo kera chiel mano nyoro.
We considered the law, both national and international, and came to the conclusion that the objection was unjustified. Therefore, overruled.
Waneno ta check mapat check ma tiu kwere logo kan check ma tiu kwere bene logo tuju ki wano ni kwe man bene uno tere pere chi wa kwere wo.
They noted some of the conduct giving rise to the charges occurred outside the territory of Uganda.
Wa korono ni jeno mogo ma time ma wa ko mora do magi o time e ka kwere mo ano pere i logo Uganda.
We had to consider whether or not we had the jurisdiction to try the accused for conduct that took place outside Uganda.
Nio kache no wan watiki tuero me piru I komnga madoti komini pigi mau time I kapere mano pere I logo Uganda.
We concluded that we have jurisdiction to do that according to the law.
Wa mogo ni watiki tuero me winyu piru meno uno wala wuche.
The fact that the accused person was captured out of jurisdiction and returned to Uganda without undergoing the process of extradition.
Waneno beninga madoti komini ki mago ki kapere ma pere I tetuero pa logo Uganda chi ki duogo Uganda la poni tichki yo me duogo dano kache otemo babal I logo mapat.
We examined the law from two aspects, state sovereignty and the human rights perspective, and found that there was no violation.
Wanio te check on what you are real matchel and ye get malo bachel check you to check where to romantic where bene na log me to where badano so no ni pecator check mo can.
The last point we had to address related to the manner in which the indictment was drafted. We had to determine whether there were fatal irregularities in the indictment.
In Magikama one nano and ye get back the market dot man see where when we're taking mirror yang kache bal matero time karme more dot.
We did find some minor irregularities which could not affect the justice of the trial.
Ada wano bal mogo makete mo na teno I karme more dot ento magno kamo kengo mendeki pido minno walmati.
So on all these 6 points, the court was satisfied that the trial could proceed to judgment without any violation of the rights of the accused person.
La habitual in dudu corono ni kamo mendeki pido yo vai ngol kop mano peketo to era tangamat. Lo from man matot tie binawane karta mano ke choya.
Thank you very much, my lord. The court will now render its verdict on the counts that the accused person was charged with.
Court dong bimio wal memege ikom adot na ngat madot komini idoro en pere.
There are 78 counts that remain after the ruling on a no case to answer.
Adot ma dong inge me wal ikom kachen tikilok na gama beru biara we are.
The court has carefully evaluated all the evidence that has been adduced by the parties.
Carefully
applied both national and international, and has arrived at a verdict on each of the 78 counts that remain. Dr. Ben, you can check.
ma doro lo Uganda ki chek bena ma doro balme bilobo so wero ki kapte ki ngol ki kom dor piara bero ya bon biju ki achera che.
This therefore is the verdict of the court for each of those 78 counts.
Naga ye ngol pa court ikom dor achera chel ma ke mo ke ikom ma dor ikom.
In count 1, the accused is charged with the offense of murder as a crime against humanity pursuant to customary international law.
Adot na chel doro ma dor ikom ne ki nek unotor nek mator chek me bal ikom dano malobe ke chek ukane madoro bal madoro me bilobo.
It is alleged that the accused, Thomas Kwoyelo, alias Latoni, in the month of March 1993, in Abera village, which is found in Amuru district, murdered Albert Oboya.
Kinoni ngarma doti komini Thomas Kwoyelo manyemo kana kinoi Latoni ini duma de mara yarabungan ya de o kabir makilone Abera mati Amuru district unero Albert Oboya.
The assessors of this court rendered their opinion on that particular count and advised this court to find the accused guilty.
Lo konko lo monko o mi utamgi ikomador man chi o mi utamgi kod no mer kinong ni bal poro ni ngarma doti kom.
Having carefully looked at the evidence and the law, this court respectfully disagrees with the assessors and returns a verdict of not guilty on count 1.
Ingingio the ben makimio
Recording in progress.
This court is thankful to the assessors for their opinion and agrees with their opinion and returns a verdict of not guilty on count 2.
Court man no ni lo konko lo mon kop o mi utam be po de bene waju ni ngarma doti kom ni porte mobile ya torna Mario.
In count 3, the accused was charged with the offense of murder under the Penal Code Act.
Dot number death, more dot minute, dot. Check Uganda.
It is alleged that in the month of March 1993, in Abera village in Amuru district, the accused killed Albert Oboya with Marisa Forthought.
The Wagoni, the death, Unero Albert Oboya, Abera forest.
The learned assessors advised this court to return a verdict of guilty. This court respectfully disagrees with the assessors and enters a verdict of not guilty on count 3.
Courtman,
in count 5, the accused was charged with the offense of kidnap with intent to murder, contrary to section 243(1) of the Penal Code Act.
Dot number page, Ngamadoti communique more dot men Marco Dano, Mirrimen, ne Ultor check me real repairmen at death, a chill, may check my Uganda manano Neopol.
It was that on the 4th of September 1994 at Abera village, which is located in Amuru district, the accused person by force abducted C4, who was a protected witness, intending that he would be put in danger of being murdered.
The Mora dot name and when Midma, when Marapera, when we are when he Bera Matia Moro, and Ngamadoti Comene Omaro, Ngamakelwani C4, then Kewalo Comero, Miri me twalo en wakana and wow.
The lady and the gentleman assessor advised this court to convict the accused person for the offense charged. In agreement with the assessors, this court enters a verdict of guilty on count 5.
Look on call on cop, on cop in the number of people to Balmalo, what that man, she caught ye, Tampa, look on call on cop, knowing a man, Balman.
In count 6, the accused was charged with the offense of kidnap with intent to murder, contrary to section 243 of the Penal Code Act, where it is alleged that on the 4th of September 1994, at Abera village, which is located in Amuru district, he abducted P4, protected witness, with intention that that witness be put in danger of being murdered.
Ya dot nama bichel, kemora dot me makudang kemiri me nakone wawo, untor check nyare pera ngam ya ter, me check me Uganda, untuwale ne ngwen me dima bungwen ma pera bungwen ya ngwen, ya bera nati ya moro, ngam dot ko me ko maho ba ngwen, man ngam ki wawo ko me wawo, kemiri me nakone wawo.
The learned assessors advise this court to enter a verdict of guilty. In agreement with the assessors, this court finds the accused guilty of the offense in count 6.
Lukon problem cop, umiotam ki kotman minongoni ngarma doti komone ute mobile man pot ye kitampa lukon kore unoni ngarma doti komone ute mobile maloba dot bichel.
In count 8, the accused was charged with the offense of kidnap with intent to murder, where it is alleged that he abducted C5, a protected victim, with the intention to put him in danger of being murdered.
Ya dot nama borong ama dot komone kimora dot me makudang kimirmen na kono wo untuwade ni eno maro sa a beach ngam ki goro kome kimiri ni menna kono wo.
The assessors advise this court to return a verdict of guilty, and in agreement with the lady and gentleman assessors, this court finds the accused guilty in count 8.
Lokon koro ngol kop umiotam ki kot number nong ni ano te mobile kot bene ye ki lokon kore ni ngama dot ko te mobile alo bekato na maboro.
In count 10, the accused is charged with the offense of kidnap with intent to murder, where it is alleged that on the 4th of September 1994, in Abera village, located in Amuru district, he abducted of Port Charles with the intention of putting him in danger of being disposed by being murdered.
Ya dot nama pa nora dorne mak kimiri mennet untuwade ni ngwen me dema bungwen mo apia bungwen ya ngwen ya bayar mati ya moro nama dot komone umaho ko Charles kimiri mennet kone wawa.
The assessors advise this court to convict the accused as charged. This court is thankful to the assessors for their opinion, and in agreement with them, finds the accused guilty and hereby convicts him of the offense in count 10.
Upon calling on top, umiotam ni umero kinong ni anote mubal pia dot man court bene poyo tampa lukon kore no ni da angadote komeni te mobile malo biketo mapa.
In count 11, the accused is charged with the offense of kidnap with intent to murder, where he is alleged to have abducted Patrick with the intention of putting Ojo Patrick in danger of being murdered, and the assessors advise this court to convict the accused as charged. In agreement with the learned assessors, this court enters a verdict of guilty and hereby convicts the accused of the offense in count 11.
Ya dot apara chill ki ko Gimara dot me makimir me net un ko ni nel ngama dot ko ni o ma Jok Patrick kimir me net the point code mo ko mi tam numero ke nong ni am ke mobile ti ko ke ye ki the point code no ni am ke mobile me lo ka dot ma parche.
The offense in count 12 is kidnap with intent to murder, where it is alleged that the accused on the 4th of September 1994 at Abera village in Amuru district with intent to put Ogena Simon in danger of being murdered, kidnapped that same Ogena Simon.
Ya dot para rio Gimara dot me makimir me net un ko wala ni ngwen mi di ma bungwen ki mara per bungwen ya ngwen ki ya pera ya moro na ba dot ko ni o ma Ogena Simon kimiri me net me wago.
The lady and gentlemen assessors advised the court to convict the accused in agreement with the advice of the assessors. This court finds the accused guilty and hereby convicts him of the offense in count 12.
Lukon calling or cop umiotam killing or cop number kenong ning at madoti community mupalme makimir menet killing or cop ben a ye kitampa at Lukon core unoni ning at madoti community utimupalma lubekat dot namapareo.
The offense in count 13 is pillaging as a violation of Article 3, common to the Geneva Conventions, where it is alleged that on the 4th of September 1994 at Abera village, the accused person extensively destroyed houses, bicycles, livestock, foodstuff, household property, and other items, while he was aware that those items enjoyed protected status within the existence of an armed conflict.
Ya dot apara der di moro dot me ya kare me luen ma toro dul check na mate me check me Geneva un ko wanya ni ngwen me di ma ngwen ba ya ngwen ya ngwen ya bera mate ya moro na ma dot ko mini o moro ka beru menuchi o palo jammi mate ot palo lera o palo le me gang cham ya mukane un en ngeo ni jammi magi ma ene balani no ke guaho gi check me Geneva Convention.
The lady and gentlemen assessors advised this court to find the accused guilty of the offense of pillaging in count 13. In agreement with the assessors, this court finds the accused guilty of the offense in count 13.
Lukon korum or cop me tam ki kod ne mer ke nong ning ama do te community mobile me ya ki karmelwen chino or cop ben ye de ki tampa lukon korum or cop no ni ngamba do te community mobile me ya ki karmelwen ya dot na para.
The offense in count 14 is aggravated robbery, which has been charged as an alternate offense to the to the offense in count 13.
Dot apara when ye yak jami luenyo jami ma igero ma no ke mor ma chala dot ukenne lobe ka dot na ma para de.
In the determination of the preliminary questions that were raised by the defense, this court held that where a substantive count has been proved, the alternate count shall be dismissed.
Amalobe ke kid ma check work kere jan korni ma no ni dot chiel ke mo no ti me dot kan no ma lobe ke dot ma ke mo ni no ke briya ma wa.
Therefore, count 14 being an alternate count to count 13 is hereby dismissed, considering that the accuser has been found guilty in count 13.
The man dot na ma para ngwen ma ubero dot bukane ma lobo dot para bete kriya mo wa piani donc no ni ngama dot ko ne o te mo balwa ho ya dot na ma para de.
In count 15, the accused was charged with the offense of murder as a crime against humanity.
Iya dot apara bi no ni ngarma dot komene otumbal menne metano bali down.
It was alleged that in the month of February 1996, at Paibi, at Yak Road, which is found in Kilak County, currently in Amuru district, the accused person killed the following people. One, Jacamino Oru, who was also known as Jackie Ocho, or Ken Wilson, or Joke Martin.
Ay adon na para beach marke moro adon me metal bali down ni kin don ke wajani ni be mario ma ha pia bunga ni bitel e paidi iyo tia mati ya moro ni na mado ti komene oner do magi da camino ruk marke mo ni jackie gachel ke Ken Wilson gachel ke Jock Martin.
The lady and gentlemen assessors advise this court to find the accused guilty of the offense in count 15, and in agreement with them, this court hereby convicts the accused of the offense of murder as a crime against humanity pursuant to customary international law.
Lo konkolo mo kop umio tam ikot na ngoning amado ti community mobile men net and kun waye kitam pa konkolo mo kop kot man no ni amado ti community mobile men net kun toro check me bal madome wilo mukene.
In count 16, the accused was charged with the offense of murder as a violation of Article 3 common to the Geneva Conventions, where it is alleged that he killed Jacamino Oruk, who is also known as Jackie Ocho, Ken Wilson, and Jock Martin, while he was aware.
Yaut nama para bichel ki mora dormen net kun tor check nama de me check me Geneva ma ku wajani eno ne o Jacamino Ru ma bere kiloni Jackie Ocho Ken Wilson check ki Jock Martin unen ngeoni joma ku dul rea ma check wakoge kana me ko
In count 17, the accused was charged with the offense of murder, contrary to sections 188 and 189 of the Penal Code, as an alternate count to the offenses in count 15 and 16. And because that is an alternate count, in charges where he had been found guilty, count 17, the charges in count 17 are hereby dismissed.
Ya dot nama para bero net nama toro check ni chel perbor we bor ni chel perbor we bungen me check me Uganda ke no ni man uberu dot ma roma ka dot me nama para ngi chel ka para bit me don no ni en o ma dot ko mo bal wo ni man ki bai wo chen dot nama para bero.
In count 20, the accused was charged with the offense of murder as a crime against humanity pursuant to customary international law, where it is alleged that in February 1996, he murdered Christine Acheng, Loum, Achupale, Mwe, Julio, and Gok Paulo.
Ya dot Rio que mora dot mennet bali condano con que wajani idima Rio mara pia pungen via bichel kama dot komene onero domagi Christine Cheng Loom Chipale Julio Chelpi Wo Paulo.
Julio is Mwe Julio.
Julio.
The lady and gentlemen assessors advise this court to find the accused guilty of the offense in count 20, and in agreement with them, this court found the accused guilty and hereby convicts him of the offense in count 20.
Control ngol kop mi tamkin ngol kop men na ngoni ngamba dote kon wote ban ne ma lo adopt rio ye kitampa control ngol kop no obene noni ngamba dote kon wote mo ban ne noni itwe en pe bal ngamba adopt rio.
The offense in count 21 is murder as a violation of Article 3 common to the Geneva Conventions.
Adopt the river chill uberu adopt men ne ma door check nama de me check me Geneva.
It is alleged that in the month of February 1996, at Abera village, which is found in Amuru district, the accused, being a commander in the Lord's Resistance Army, commanded an attack on the civilians, namely Acheng Christine, Lum Achupale, Mwe Julio, and Gok Paulo, in circumstances where he knew that they were protected as civilians in an armed conflict.
Ke wagani idema Rio Mohapiara when we are Bichel, and not the commonly material commander, me LRA Carmelo Umonyo, Christine Acheng, Lum Achupale, Julio Mwe, Achel Gok Paulo, Umneoni, Joman, Macharo Dulrea, check me Geneva Convention, no Guahoge.
The lady and the gentleman assessors advise this court to return a verdict of guilty. This court is thankful for their opinion and in agreement with them finds the accused guilty and hereby convicts him of the offense in count 21.
Lokon kolong ol kop mi utam kino ol kop menongoni ngamat dote komene otemu balman me atia dokro echeli ilu ol kop ne poyo tampa lokon kogi no bereni ada ngamat dote komene otemu bal mando bato dokro echel ne.
The offenses in count 22, count 23, count 24, and count 26 are murder contrary to section 188 and 189 of the Penal Code, and were charged as alternate counts to the offenses that were brought in count 20 and count 21.
Adopt mati bal mati ya adopt pero rio pero der pero gwen pero bichelu beru bal adopt me bal maroma ki adopt mati no ni ngama dote ko ngati bal ya adopt pero chel pero rio.
Because they are alternate counts, this court hereby dismisses them.
Piano beru bal maroma ki bal mati ya adopt mo kanene court man piano wa.
In count 31, the accused was charged with the offense of imprisonment as a crime against humanity pursuant to customary international law.
Yeah, dot pe chiel ki mora dot me Katudani Butch Pero ma daber bal dano unno ki tiu ki check me mador bal madon me willow.
It is alleged that on the 4th of March 1996, at Abera village, which is located in Amuru district, the accused person, being a commander in the LRA, detained, seized, and held a group of civilians called Rodento Ochola, Massimo Obola, Oye, Samuel, Ochi, Dr. Sabino, Oboli, Ola, Oriem, Quirino, Okot, Antonio, Okoya, Maurencio, and Onai, with the intention of compelling government to refrain from attacking the Lord's Resistance Army.
Ki kokni inengue angwen me de madde ma yara mwendo ya bichel ki ya bera ya moro ngamba dotti komeni umago jomagi tu guakogi jona gina ye Rodento Ochola Massimo Obama, Oyet Samuel, Ochi Dr. Sabino Oboli Oala, Oriem Quirino, Okot Antonio, Koya Mavencio, Kinga Sema Coloni Onai, Imiri me Juekogamente Peme Beruka Monyo Dul by LRA.
The lady and gentleman as professor advises court to find the accused guilty of the offense, and in agreement with them, the accused is found guilty of the offense of imprisonment contrary against as a crime against humanity, and hereby convicts him.
Lukon Kolmo Ko Mio Area Ning at Madoti Comini, Otamo Balman, Ye Kitampa, Kolmo Kop, knowing at Madoti Comini, Otamo Balman, Toro Checkmati dot the
In counts 33, count 34, count 35, count 36, count 37, count 39, and count 40, count 41. The accused was charged with the offense of kidnap with intent to murder.
Dot Perdet Vedek, Perdet Wen, Perdet Beach, Perdet Bero, Perdet Buen, Pierre Wen Wechel, Amadot Comini, Gimara dot me Marco down to Miremene.
It was alleged in those counts that the accused abducted Rodento Ochola, Massimo Obama, Oyet Samuel, Ochi Dr. Sabino Oboli Ola, Okot Antonio Okoya Maurencio, and Onai, with the intention of putting them in danger of being murdered.
Kimora Adodni, Nadma Doti Comini, O Mago Makiloni, Rodento Ochola, Achelki Massimo Obama, Achelki Oyet Samuel, Ochi Dr. Sabino Oboli Ola, Achelki Okot Antonio, Achelki Koya Mavencio, or Narasha Macrone or nine, Kimiri, Neko, and Nekogiwa.
The lady and the gentleman assessor advises court to find the accused guilty on those counts. And this court therefore finds the accused guilty on count 33, count 34, count 35, count 36, count 37, count 39, count 40, and count 41.
Lukon calling on cop, Umiotam he got me Nongoni and Amadotikono Temobal, Magine Makudan, Kimirame, Lumol Kobe, Yeki, Tampa, Lukon Kogi, Ki Unoni, and Nadmadotikono Temobal, Ia dot Gardet Gadet, Gardet Wen, Gardet Beach, Gardet Bichel, Gardet Bero, Gardet Buen, Pierangwen, Pierangwen Wechel.
In count 42, the accused person is charged with other inhumane acts as a crime against humanity.
Ia dot Piera when we are real, Nama dot Comini, Kimora dot Metim Moguma, the war de Opadano, by Carabali Comdano.
In that count, it is alleged that in the month of February 1996 in Abera village, which is found in Amuru district, the accused person commanded an attack on the civilians called Acholi Vito and David Okelo, who enjoyed the protected status, and caused suffering and serious bodily injuries to them.
Kimora dot ne, Ibime Rio, Magapia Muna Bichel, Pia Bermanti Moro, Natma, dot Comini, Umonyo, Dul Rea, Makimoni, Achori, Vito, Kachel David Okelo, ma check wako gi ma chara jo ma pere ko matiga time.
The lady and gentleman assessor advises court to find the accused guilty on that count, and in agreement with them, this court finds the accused guilty and hereby convicts him of the offense in count 42.
Upon calling on cop, whom your time will cop men on me, Gamma Dotti Community Mubal, Dahia Dotman, whom Guye Kitampa, upon calling on cop, the cop and Noni, Gamma Dotti Community Mubal, and the Buhan.
In count 43, the accused is charged with the offense of cruel treatment as a violation of Article 3, common to the Geneva Convention.
We are dot there when we are there. Gimara dot me. I won't married. Then you malate. My door check. Namade. My check. My Geneva.
In that count, the prosecution alleges that Kwoyelo Thomas, with others at large, in the month of February 1996, in Abera village, which is found in Amuru district, while a commander in the Lord's Resistance Army inhumanly assaulted Ochan Vito Acholi and David Okello while he was aware of their status as protected persons under the Geneva Conventions.
Gimara dot me in the Mario, Mahapia when we are Bichel, Yabera, Matia Moro district, Namba dot T Comeni, Ma Karahinit, Commander, LRA, and one your Rio Makigogini, Chan Vito, Achore, Kachelki, David Okello, Kunyangani, check Wago Jompan, Machala Dulbea, Magente, Watagatene.
The lady and gentleman assessors found in their opinion that the accused should be found guilty, advise the court to find the accused guilty, and in agreement with them, this court finds the accused guilty of the offense in count 43 and hereby convicts him.
Look on calling on problem, your time, will come with the Nong, and Batoro community mobile, job like go ye, Kitampa, upon Kogi, knowing a Madote community mobile, Mador, when we are there.
In count 44, the accused is charged with the offense of outrages upon personal dignity as a violation of Article 3, common to the Geneva Conventions.
Here dot there when we are when the more dot me Timarani Compeo Padano, un toro check do check namatek, may check me Geneva.
The prosecution alleges that Kwoyelo Thomas, with others at large, in the month of February 1996, in Abera village, which is now found in Amuru district, while he was a commander in the Lord's Resistance Army, commanded an attack upon a group of civilians who at the time were taking no part in the hostilities, and ordered these forces to inhumanly assault Acholi Vito and David Okello, who enjoyed that protected status.
Kewagani in the Mario Maka Terabungana Bichel, Kia Bera, Matia Moro, Namadoti Comini, Carmine Tie, Commander LRA, Umonio Dulrea, Naika Bermenuchi, Umonio, Gay, Wono, Dana Machado, Chan Vito Achore, Kachelki, David, Pungiani, Jo Magi, Pumero, Kibwaki, Ite, Check Macadoro, Dwayne, Magino Dulrea, Mate Popo.
The lady and gentleman assessor advised this court to find the accused guilty, and in agreement with them, this court finds the accused guilty and hereby convicts him of the offense in count 44.
The calling of cop, Meotan, court, New American Nongni, and Namadoti community mobileman, Ye Kitampa, Locon calling of copy, Locopel Noni, the Namadoti community mobile, Dobeka dot, and when.
The accused was charged with the offense of attempted murder in count 45 under contrary to section 204 of the Penal Code Act. That count was an alternative count to the two offenses in count 44 and count 42. Being an alternate count, it is hereby dismissed in light of the conviction in count 44.
adopt Yara and when we are big no tea time on net.
Now, in count 47, the accused was charged with the offense of other inhumane acts as a crime against humanity pursuant to customary international law, where it is alleged that on the 4th of March 1996 at Abera village in Amur district, while he was a colonel in the Lord's Resistance Army, commanded a group of forces to attack civilians who were under his command, and they inhumanly assaulted B2, a protected victim, B4, a protected victim, B6, a protected victim, B7, a protected victim, and one Angelina Oriem Ataro.
Kiwani remember when me do me adet mga piarmuna bichel ya bara yamati ya moro ikama kama dote community kano LRA umonyo dul rea ma ikabero meno kun aki mora dot me tembu kenne ma perwa aki kit me dana iku temarani ikom domagi ma gogini ba rio ba ngwen ba bichel ba pero ingara chama dwari Julina Uganda.
Yes, the accused, the assessors advised the court to find him guilty, and he's hereby found guilty by the court and convicted.
Do ko ngol kop ko mi kam niki nongni eno te mobile me lobe kadok ngwan we pero man ko no ni ada eno te mobile malo be ke adok ngwan we pero.
In count 48, the accused is charged with the offense of cruel treatment as a violation of Article 3, common to the Geneva Conventions. In that count, it is alleged that the accused, Thomas Kwoyelo, with others at large, on the 4th of March 1996, at Abera village in Amuru district, while he was a colonel in the Lord's Resistance Army, commanded an armed attack against a group of civilians who were not taking any part in the hostilities, and those civilians were B2, B4, B6, B7, and Angelina Ataro.
Ya dot ngwan me boro Gimara dot me timarani komdano mukane ama ko check ama det me check me Geneva un kiwajani Thomas Boyle kachel ke yo mukane LRA inondo ngwen bidina det ma pier ngwen bichel ki abera mate ya moro umonyo dulrea ma gente ko matika timeni un timarani kom domagi ba rio ba ngwen ba bichel ba bero kachel ke Angelina Oriem Ataro.
The lady and gentleman assessor advises court to find the accused guilty of the charges in count 48. In agreement with them, this court hereby finds the accused guilty and convicts the accused of the offense in count 48.
Lukon ko ngol ko ni tam ni mer kinong ni ngama dote kongo te mobile ma lobe ka dot ngan me boro un ye ke tampa lukon ko ngol ko be no ni ngama dote kongo ni te mobile ma lobe ka dot ngan me boro.
The accused in count 49 is charged with the offense of outrages upon personal dignity as a violation of Article 3, common to the Geneva Conventions.
Ngama dote kome Gimara dot ni eno te mobile net arani ikom temarani ikom deo padano ma mante ya dot piarangwen ya bongwen toro check det me check me Geneva.
It is alleged in that count that the accused Thomas Kwoyelo, while with others at large on the 4th of March 1996 in Abera village, which is found in Amuru district, at the time being a colonel in the Lord's Resistance Army, commanded an armed attack on a group of civilians who were not taking any active part in hostilities and ordered his forces to inhumanly assault B2, B4, B6, B7, and Angelina Ataro Oriam.
Ke wajo ni inendo angwen medme ade piar bungen wi bichiel ki aber ma tia moro Thomas Kwoyelo ka chel ki jom kan ma put pere peke ma hogi magen karma karmen no ti kanon LRA geno monyo ka go temarani ikom jomagi ba rio ba angwen ba bichiel ba bero ka chel ki Angelina Oriam Ataro.
The lady and gentlemen assessors advised the court to find the accused guilty of the offense in count 49, and in agreement with them, this court hereby finds the accused guilty and convicts him of the offense in count 49.
Magumio wajo ni miere kinong ni ngamado te komote mubal malo pikado ngwen man golko bene no ni ada ngamado te komote mubal malo pikado ya ngwen ya ngwen.
The offense in count 50 arises out of the attack on Pagak camp, where it is alleged in count 50 that the accused with others still at large while he was a colonel in the Lord's Resistance Army on the 16th of May 2004, coordinated, ordered, and directed an armed attack on that same Pagak internally displaced people's camp, where the following people were killed. 1. Nyeko Bosco. 2. Amon Jennifer. 3. Achan Shida. 4. Ato Susan. 5. Akwero Harriet. 6. Anena was the daughter of Aloyo Konsi. 7. Martina Awol. 8. Edisa Lapobo. Next, Akwero Nancy. Then Dorothy Akech. Next, Achayo Josephine. Then Achiro Rose. Then Kilama Eric. Next, Amal Ketty. Then Opita Mateo. Then Pongo Christian. And finally, Ochira Eric.
Ya dot man logo mo no time ikam Pagak ki wajo ni ngamado te komunik achiel ki jom kan ma put mauno gen LRA Carmeno gen go ni da par achiel mi me beach mo hal brio ka ngwen go mo meno chi go nego jomagi magena ye Nyego Bosco Amon Jennifer Achan Shida Ato Susan Akwero Harriet Anena Mobile Nyakpa Loyo Konsi Martina Award Edisa Lapogo Akwero Nancy Dorothy Akech Achayo Josephine Achiro Ross Kilama Eric Amal Ketty Obira Mateo Akpongo Christine Kachelke Ochira Eric.
The lady and gentleman assessor advised this court to find the accused guilty of the offense in count 50, and in agreement with them, this court hereby finds the accused guilty of the offense in count 50 and convicts the accused person.
Tampa lo control mo kop magumyo tamno merkinong ning amado te konote mubal un ye ke tampa lo control mo kop pot no ni ada ngamado te konote mubal malube ke adot Pier Beach.
In count 51, the accused is charged with the offense of murder as a violation of Article 3, common to the Geneva Convention, where it is alleged that Thomas Kwoyelo and others at large on the 16th of May 2004 at Pagak, I'll read that again. On the 16th of May at Ogo Parish, which is a Pagak internally displaced people's camp. While he was a colonel in the Lord's Resistance Army, he ordered and directed an armed attack on that same Bagak internally displaced people's camp, where the following people were killed. These people were civilians taking no active part in the hostilities and were protected under the Geneva Conventions. The people are Nyeko Bosco, Amon, Jennifer, Achan, Shida, Ato, Susan, Akwero, Harriet, Anena, the daughter of Aloyo Konsi, Martina, Awor, Edisa, Lapobo, Akwero, Nancy, Dorothy, Akech, Achayo, Josephine, Achiro, Rose, Kilama, Eric, Amal, Ketty, Opita, Mateo, Akwongo, Christine, and Ochira, Eric.
Yeah, der bit my chairman dot net on Torchic Geneva Convention, signal that Geneva Convention. When in the power, they are the chair, Midema Big Mahalabrio Kangwen, Yobo Parish, Maati Pagak, Yamoro district. Thomas Kwoyelo can check Lu Watamukane, Bano MT LRA Karenuni, Umonyo Kabelmeno, Neho Jomagi, and Yeho Bosco, Amon Jennifer, Achan Shida, Ato Susan, Akwero Harriet, Anena Mugarinak Palo Konsi, Martina Award, Edisa Lapobo, Akwero Nancy, Dorothy Akech, Achayo Josephine, Achiro Rose, Kilama Eric, Mal Ketty, Obira Mateo, Akwon Christine, Kachel Ochira Eric.
The lady and gentleman assessor advised the court to find the accused guilty of the offense. In agreement with the assessors, this court hereby finds the accused guilty and convicts him of the offense in count 51.
Lokon ko ngol kop umiotano merkinong ni admado tiko no temubal cheketwe wao keman ngol kop na ye tampa de makono kogi chino ni admado tiko ni otemubal mal lobeki adot Pierre Bigwi Achel.
The accused was charged with the offense of murder contrary to section 188 and 189 of the Penal Code. As alternate counts, the offenses in counts 50 and 51. The counts in which he was charged are 52, 53, 54, 55, 56, 57, 58, 60, 61, 62, 63, 64, 65, 66, 67, 68, and 69. These are all alternate counts, and in view of this court's decision in the preliminary objections, those counts will now be dismissed since they were charged in the alternate.
Malobeki dot their beach we are real, their beach we are dead, their beach we are when, their beach we are bichel, their beach we are bero, their beach we are boro, their bichel, their bichel we are real, their bichel we are dead, their bichel we are when, their bichel we are beach, their bichel we are bichel, their bichel we are bero, their bichel we are boro, their bichel we are when, Magi we dot ma ruaraki adopt ma bit chel bit ma dong no ni ngat ma dot ko ni ko to bal we ho yang kot man bai wo ket ma orate wo.
In count
there's a request to change the interpreter. Can we have Mr. Donga call, please?
Wendy, what are you doing?
Councillor, there is a friendly touch of arms.
You ready, Mr. Dongakulu?
Yes, my lord.
In count 70, the accused is charged with the offense of pillage as a violation of Article 3, common to the Geneva Conventions.
Ipiak me bal nama piar biro, ngama adoti kome, kime ire adot me, ya.
It is alleged that on the 16th of May 2004, at the Park Internally Displaced People's Camp, he extensively and wantonly destroyed 544 huts. He destroyed foodstuff and household property, which was protected property under the Geneva Convention, and there was no justified military necessity for that destruction.
Ipiak me bal man operin la para bicher, me doma beach. Papo kema me IDP, ngama piak me bal ti kome, mano tikano, idulme adwi pa LRA, okupe loro mio rokcha me pol do mon, ikomdan matikama kono, loro balo jeme ma pol, matalo odi piar beach, mia beach piar ngwen cham jeme me odi ma par, man toro chekme Geneva Convention, comme petit ngej money man ono jemati o kemeki dwayne mo carmeno.
The lady and gentleman assessor advises court to find the accused guilty of the offense in count 70, and in agreement with them, the accused is hereby found guilty and convicted of the offense of pillage as a violation of Article 3 common to the Geneva Convention, and he is convicted.
Donc je m'accorde ponyo lungol ko kingol no ne mano na mabiak mabal ti komani o porte balman donc bien mo on mi fo ti pan donc ben lungol ko ben mo on mano ti kakare ma lope ki bal na piar pero ma tiaro kit ma yak ma tiaro tor chef me Geneva Convention.
In count 71, the accused is charged with the offense of other inhuman acts as a crime against humanity, pursuant to customary international law, where it is alleged that while he was a colonel, the Lord's Resistance Army commanded an attack on the Baganda internal displaced people's camp, and by other inhuman acts, he intentionally assaulted the following protected persons: H 34, H 5, H 36, H 37, H 38, H 39, H 67, H 68, H 69, and H 71.
Biak na bal ti albier wa chel. Wacha no nga mabiak na bal ti kume. O tingo jeme makelo aranyi ma ikumbrano ma toro chek me bebero ma perwata ki chek me wilogo. Donc man operine rapara bichel me de ma beach ipaga IDP camp ma joma ki bolo aranyi ikumgi opero H pierde ku ngwen pierde beach pierde ku bichel pierde ku bero pierde ku boro pierde ku ngwen pierde bichel ku bero pierde bichel ku boro pierde bichel ku ngwen pierde bero ki pierde bero ku chel man balma onotor chekme Geneva Convention.
The assessors advise this court to find the accused guilty. In agreement with them, this court hereby finds the accused guilty of the offense in count 71 and hereby convicts him.
Jo makonyo court kingol gumo de meno bal man otime dok bene court bene mogoni man bal otime dong te lokni meno ngarma bal ti come o chero toro chek ti bal man me piara bier we chel makwaka ki yak.
In count 72, the accused was charged with the offense of cruel treatment as a violation of Article 3, common to the Geneva Conventions. It was alleged that the accused, as commander and colonel in the Lord's Resistance Army at the Pagak camp on the 16th of May 2004, coordinated and ordered an armed attack on that Pagak internally displaced people's camp, where the following people were intentionally assaulted while it was clear that there were civilians who were taking no active part in the hostilities and were protected persons under the 4th Geneva Convention. Those people are H34, H35, H36, H37, H38, H39, H67, H68, H69, and H71.
Biak me bal na ma biar bir wario to mora dot no ni na ma biak me bal ti come o bolo rani timotim kigero ikom dano ma jingi ti pinkan maman toro pen siek ma de ma siek me Geneva ma karma ine da par biche no ma beach karma anti kanol dokti kamanda pa LRA man beri ka beri me paga don joma ki bola rani komgi Obero joma ke gwa ochalgi o makelwani H piara dek ya ngwen piara dek ya beach piara dek ya bichel H piara dek ya biro H piara dek ya boro H piara dek ya ngwen H piara bichel ya biro H piara bichel ya boro H piara bichel ya ngwen H piara biro ke H piara biro ya chel ma aranye maketimoni oberi komreya mano pekitiki kupe mo ken ilwenyi karmeno Amano chero nyono chen chikma ngwen me Geneva Convention.
The assessors advise this court to return a verdict of guilty. In agreement with them, this court hereby finds the accused guilty and convicts him of the offense in count 72.
Jong ingol ineno nyo itam pa joma konyo court ingol kuno oni mano nganma adoti kume nero kimi ire bal iwie bi balman longol ko bene kumo oni mano ada ngarma bal ti kume otor Sheikman donc mo ni mano mer onon fod malupe ki balman.
In count 73, the accused was charged with the offense of outrages upon personal dignity as a violation of Article 3, common to the Geneva Conventions. It is alleged that the accused, with others at large, on the 16th of May 2004, while he was a colonel in the Lord's Resistance Army, coordinated an attack on the Pagak internally displaced people's camp, where the following civilians who were taking no active part in the hostilities and who were protected persons under the Geneva Convention were severely assaulted, and he was aware of the circumstances which provided them with a protected status. The victims are H34, H35, H36, H37, H38, H39, H67, H68, H69, and H71.
Ibiak me bal na mapiar bir we der ki wachi ni mano ngatma adoti kume utimo timarani ma chero toro twero ki wora tum dano reya maman uchero nyono chen chik mena madek ma chiel ma tie te Geneva Convention mani mano timani nda para bichel me duma beach ikabero me paga ikama paga ma eno no ti kano dokla do wi mon me LRA donc joma mon uburu komgi ubero joma ke gwa nyingi o ti chalo HPR dek we ngwen HPR dek we beach HPR dek we bichel HPR dek we biro HPR dek we boro HPR dek we ngwen HPR we biro HPR bichel we boro HPR bichel we ngwen HPR biro HPR biro chel mama no rea ma petitiki no pekiti gurwa wigi ilwen mo ken ma mano charatoro chek ba ngwen me Geneva Convention.
The lady and gentleman assessor advise this court to find the accused guilty, and in agreement with them, this court finds the accused guilty and convicts him of the offense of outrages upon personal dignity under count 33.
Yo madam ngolo ko nyo court ngol gumi otama me gin meno mir dinong ni ngan ma doti come timo balman dok bene court beno mo ni man balman otime kum joma kilwa nyinge malo ni mong mier en long kitme fodni ko balo ka Kenya.
In count 74, the accused is charged with the offense of murder as a crime against humanity, pursuant to customary international law. In that count, it is alleged that the accused, on the 6th of January 2005, at Kulu Okal, which is located in Bira Omba village, currently in Amuru district, while he was a colonel in the Lord's Resistance Army, commanded an armed attack against civilians who were taking no active part in the hostilities and killed Ochaya, John Ojara, John Oketayot Lawoko, Charles Achaye, Okema, Ochuke, and Ogok Phil.
Ibiak me bal piar bier we ngwen kino ni mano ngan ma adoti kome o timo bal mener mamantor me wilobo ma ano time ini ora pichel me joma chel ma Aliba rio kya bich ikul pa okal ma tie char me bira omba ma tie I baroban ya moro ma kumbedini ikar ma eno tie kanol madoro wi adulme LRA ubola mon aranyi ikomrea magima nyingitie Uchaya John, Ujara John, Okera Yor Lawa Charles, Achaya Okema Chuke, Ki Ogwok Odong Philip. Maman onojomano miyoki gwokki ikir me chiek me Geneva Convention. Ma en beno timo komngeyo ni jema kumano joma kimiyoki gwokki te chiek.
The assessors advise the court to find the accused guilty, and in agreement with them, this court finds the accused guilty and convicts him of the offense in count 74.
Dong joma konyo court kingol gu imita makomiyo ki court kunoni ngat ma biak me balti kome otor Shekman dong mero nong fod malugo Shek piar bal piar biro ngwen man otor court bene moko ni mano ngat man o toro Shekman dong mero nong fod maluk pekere.
In count 75, the accused is charged with the offense of murder as a violation of Article 3 common to the Geneva Conventions, where it is alleged as a colonel in the Lord's Resistance Army, the accused person on the 6th of January 2005 at Kulu Okal, which is located in Bira Omba village, now in Amuru district, commanded an attack on civilians who were taking no active part in hostilities and killed Ochaya, John Ojara, John Oketayot Lawoko, Charles Achaye Okema Ochuke, and Ogok Odong Phil, while he was aware of their protected status under the Geneva Convention.
Biak me bal piar bier we beach inoni ama adoti kome o ne machertor Sheikh adek chiel me Geneva Convention amano time iniendo chiel me domachel I kapere makilwani kulu pa okal matie ichar me bira omba madong ti amor makumbedini ikarma eno tie kanol madoro widul me LRA dong joma kiwachi eno ti marani gi obedo rea mano pekiti ilweny man manyinge yetie joma kineroge Ochaya John Ujara John Kerayot Lawa Charles Achayo Kema Chuke Ki Ogwok Odong Philip Manomero Igwaki Maluka Kipen Chekma Geneva Convention.
The assessors advise this court to find the accused guilty. In agreement with them, this court finds the accused guilty and convicts him of the offense in count 75.
Yung makonyo court kingol guno gumi tamgin maro no mer kinong ni maro ngati ubal balman court bere umogoni maro bal eni otime donc mer kimi fort mo bore.
In count 76, count 77, count 78, 79, and 8, the accused was charged with the offense of murder under the Penal Code Act. Those charges were alternate counts and will be dismissed in light of the findings of this court in count 74.
Donc, ibiak me bal nama piara biro we abichel, piara biro we biro, piara biro we boro, biro bungwen piera boro kinoni man bal madong tio bama ko bal mo kana manong nanen kino balo kaye chidong court biro man perote.
In count 81, the accused was charged with the offense of enslavement as a crime against humanity pursuant to customary international law.
Biat me bal pier bor wechel kinoni ngan ma doti kome uberika bal me makudan me berchalo pi ma mege ma tor chek me wilogo ma tor chek me wilogo.
It was alleged in this offense that the accused, Thomas Kwoyelo, with others at large, in February 1996, specifically in February 1996 and January 1998, in Perechu village, which is now in Amuru district, and also in parts of southern Sudan while he was a commander in the Lord's Resistance Army, forcefully took away TR. TR is a protected witness and victim, and he forced her to marry one of the LRA combatants who were under his direct command.
Kiwajani ikina me de Mario ma ali bachel mi abungwen per bungwen obchel video ma chel ma ali bachel mi abungwen per bungwen boro ikaber me perechu mati ya moro i bot lobo mo kana mati ko piny me Sudan ngar ma biak me bati ko me o mio arane dogo ko panyo ngara chel da chel o mio me bero tek da pa la moña chel pa LRA mati te twer ma mege.
The assessors advised this court to find the accused guilty of that offense, and he is hereby found guilty and convicted.
Yo mamio tam because mio tam kinimano mir kinong ning ngar ma doti kome utimo balman court bene ungio noni ada gumo ni balman otime dong mir kimi pot ikum balman balna ma piara bor wia achel marufa kichir.
In count 82, the accused was charged with the offense of outrages upon personal dignity as a violation of Article 3, common to the Geneva Conventions.
Ibiak bal piara bor we ario noni ngalma adoti kome o timoti marani maperwata kichir mator kumdano mator chef ma def me Geneva Convention.
It is alleged that the accused, while he was a commander in the Lord's Resistance Army in the place now in the village of Perechu in Kila County, which is now in Amuru district, between the months of February 1996 and January 1998, and also in parts of southern Sudan, forcefully took away TR, who is a protected witness and victim, and he forced her to marry one of the LRA combatants who were under his direct command.
Ibiak bal piara bor we ario wachi ngalma adoti kome ikirame dwe ma ario ma ali bachel mi abungwen per bungwen we bachel idwe ma chel ma ali bachel mi abungwen per bungwen we boro icharo me perechu mati ke la county madong community Moro district eno ti kitwer ma mege chalo kamanda pa LRA ka kwanyo ngan ma klori ti ara mati chaden dok ben ngan ma aranya ni kipoli kome me mio en ma chalo dago bot la loin pa LRA mati te twer ma mege.
The assessors returned an opinion where they advised the court to find the accused guilty, and in agreement with them, this court finds the accused guilty and convicts him of the offense in count.
Joma konyo ko ke ngol go mi tam kin mano mir kinong ni mano ngan ma doti kume otoro chef ite balman court bene mogo ni mano ngan ma doti kume otoro chef ite balman men na ma pier bor rio dong mero onong fot ma mopore.
In count 84, the accused was charged with the offense of rape as a crime against humanity pursuant to customary international law. It is alleged that the accused, between the months of between the years 1997 and 2004 in the Kilak Hills in Kilak County, which is now located in Amolu District. While he was a commander and a colonel in the Lord's Resistance Army, he subjected an abductee who is known as, who was identified as LW, with conduct read that again. That was rape as a crime against humanity, and the offense was committed in 1997, between 1997 to 2004, and the LW was a protected person under the Geneva Conventions. The assessors advised this court to find the accused not guilty of the offense in count 84. This court respectfully disagrees with the assessor's opinion and finds the accused guilty of the offense and convicts him of count 84.
Ibiak me bal piara bor we ngwen kimoro adot me mak tek machero mak me beru tek machero toro chek me wilowo dong man ki wach no time ikire me ma alwachiel mi abungwen piar bungwen we abiro ki ma alwario kya ngwen e Kila Hills mati ya Moro district maki wach ni nan ma doti kome manoti commander dok kanol itul ba LRA ene ma hodano ka dharma kilo kakani LW no lawa ma uber ngama igwa o shaleo do ko ber kete ter ma chalo da one donc joma ngolo konyo kor ki ngol ki wachin mano eni no premier ki mo bal en iwi ngama do ti kuma ento court ononi eni bal ma peron wene ki kuma donc miero erno fot mo pore ki bal man me na ma pier boro ya ngwen.
In count 85, the accused was charged with the offense of torture as a crime against humanity pursuant to customary international law, where it is alleged that the accused between the year 1997 and the year 2004 in Kilak Hills, in Kilak County, now in Amuru District, while he was a colonel and a commander in the Lord's Resistance Army, subjected an abductee who was identified as LW to repeated incidents of forceful sexual intercourse, conduct which inflicted severe mental and physical torture upon that witness, LW, and this conduct was nowhere associated with the armed conflict, and inflicted the torture on her while she was a protected person under the Geneva Convention.
Biak me bal pier bor we bi mano beru bal me awon machero toro chek me wil dobo ino ni mano kirme ma ale bachel mi abungwen pier bungwen wa biro ale bari ok ya ngwen ka beru me Kila Hills mati Kila County ya Moro district ngan ma do ti come mano ti commander nyo do wi group LRA ro ti kanol bene pero tek ki chama non LW kibat mo berka di done me pour que detecteur mano ke awon me twin ajiji mater mamano certoro me Geneva Convention.
The lady and gentleman assessor advised this court to find the accused not guilty. This court respectfully disagrees with the opinion and finds the accused guilty of the offense and convicts him of torture as a crime against humanity in count 85.
Joma konyo court kingol in tama megi ko miyo ni mano bal en kamiero tukwe tiel ngama adoti kome ento kero noni peti kome no ngama adoti kome pero wene ki bal en donc moro bal en tie machalo bal mamero ki mi ye podie bal nama pier boro ya bich.
Count 86, The accused was charged with outrage upon personal dignity as a violation of Article 3, common to the Geneva Conventions, where it is alleged that the accused, while he was a commander, a colonel in the Lord's Resistance Army, between the year 1997 and 2004 in Kilak Hills, Kilak County in Amur District, subjected an abductee who is identified as LW to repeated incidents of forceful sexual intercourse conduct, which was which inflicted severe physical and suffering on the victim, and that conduct was not associated in any way with the character of the conflict, which was non-international in nature.
Birme bal Pierre Borwe Bichel, nan ma doti come, Gimara dot numero enotio, itwe remetimo arani, macher toro, war, ikom dano, mautor, chek, me na mader, me Geneva Convention. Ma ki watching one ikine me ma Aliba Bichel, mia pungwen ki Pierre Pungwen ma Pierre, ma Aliba Rio Kangwen, ikabere me Kilak Hills, maki Kilak County Yamoro District, karma anti commander me LRA dot Canol, LRA en utiu kigero ter ikumngan ma eno maga makiloni LW kakany uberka beru kerero ter maman ono sharkela awon mater ipo kangat man dok bene eni utor chef melwen ma tiete ben chef me Geneva Convention.
The assessors advise this court to find the accused guilty and in agreement with them is hereby found guilty and convicted of the offense in count 86.
Donc, njokoro nong ni ngat ma doti ko bal man me Pierre Borwe Bichel kot beno mo oni bal man motime donc mero ngat ma doti ko non fod mo pore ki bal Pierre Borwe Bichel.
Now in count 87, the accused is charged with the offense of violence to life and person, in particular cruel treatment and torture as a violation of Article 3, common to the Geneva Conventions.
Birme bal Pierre Borwe Biro, no nimeno Gimara ti kigero ipo ti kumdano tutwale ti kigero ti awon mater toro ben chef me adef me Geneva Convention.
It is alleged that between the years 1997 and 2004 in Kilak Hills, which is now in Amuru District in northern Uganda, and also in some parts of southern Sudan, while he was a commander and a colonel in the Lord's Resistance Army, he subjected an abductee who is identified as LW to repeated incidents of forceful sexual intercourse, and that conduct inflicted severe mental and physical suffering on that victim. And at that time, she enjoyed the status as a protected person under the Geneva Conventions, and he was aware of the protected status of that victim.
Ya Dortman, kichimoni mano ikirame ma Aliba Bichel mia bungwen ki Pierre Pungwen ma Biro, ki ma Aliba Kangwen, Kilak Hills mati Kilak County malong tia Moro District Berine, na ma Pierre me balti kome, mano te commander me LRA dok te kanon, ki bot kaber mukene me kupin me Sudan, en beno ti tutwer wa meke, ikom ngar ma eno maga makilungo kanye, chaden elwa la wa el ti ukere me bedo kere tek challa choki dago, mamano kela won ki awano ma tek chwing ikom ngar ma man LW.
The lady and gentlemen assessors advise this court to find the accused not guilty on count 87. The court respectfully disagrees with them and finds that the accused is guilty of the offense in count 87 and hereby convicts him.
Joma konyo court ki ngol gumiyo tamgi ononi mano miyo peki twe balman ikum ngarma doti kume endo court ineno mamegi wachipe bali edi elperon wene kiye donc twe balman wiye donc miyo kubinong fod mo boy balman Pierre Borwe Piero matoro twero kigero itijawoni kumdano.
The offense in count 88 was charged in the alternative to counts 87, 86, and 85 under the code, and because the accused has been found guilty on those other offenses, that alternate count dismissed.
Bierme bal Pierre Bor we boro onononki balma Obama Bama kumbalme Pierre Bor we biro Pierre Bor we pichel ki Pierre we bor we pich ma onotor chetme Uganda ma kwa o beru gidano tek chidong kod ononi kitma dong kimio yere fodo ibal ki none obal mamalo dong pe kiro no ibal ni kor di rote obaya chen.
In count 89, the accused is charged with the offense of rape as a crime against humanity, where it is alleged that the accused between the year 1996 and 2005 in the Kilak Hills, in Kilak County, in Amuru District, which is found in northern Uganda, and also in some parts of southern Sudan, while he was the commander and the colonel in the Lord's Resistance Army, subjected an abductee identified as NS, and the subjected her to repeated incidents of forceful sexual intercourse, conduct which inflicted severe physical and mental suffering upon that NS. This was act which was inflicted on a protected person or a person protected under the Geneva Convention, and that the accused person was aware of that protected status that this victim enjoyed.
Ite bal Pierre Bor we when over bal me mak tek beru gidano tek ma cher toro chet me wilogo maki wachi ikire me ma Aliba chel mi abwen Pierre bwen o chel ma Aliba rio kya bi ikaber me kilak hills matie ikilak county ya Moro district kibene ibot kaber mu kene me ku Sudan me ko pin ngado ti ko man ti commander do canol itulba LRA uti kitwa ke ikonga ma eno maga makilungo kanyi taden NS berka ke tek kar malach ina ne otujo makelo awano me twin me wich donc ban perlu ka kispen chip me Geneva Convention mador ke pamero dano ti kere kom na wore kar melwen tutwalere.
The assessors advised this court to find the accused, and in agreement with them, the accused is found guilty and convicted of the offense in count 89.
Donc jo makwanyo kot kingol itama megi gomiyo ni mano merkid nong ni mano ngar mabiak me balti kome ada porte chip me balman kot beno mogo ni mano ada ngar biak me balti kome utimo balman na mapia bor we bongwen donc mero nong fot mapore ki bal pia bor we bongwen.
In count 90, the accused is charged with the offense of torture as a crime against humanity, pursuant to customary international law. It is alleged that between the year 1996 and 2005, in Kilak Hills, in Kilak County, in Amuru District, and also in some parts of southern Sudan, while he was the colonel and the commander in the Lord's Resistance Army, he subjected an abductee who was identified as NS to repeated incidents of forceful sexual intercourse, conduct which inflicted severe mental and physical suffering upon NS. And NS at the time enjoyed protected status under the Geneva Conventions, and that the accused person was aware of the victim's protected status.
Donc ibet me bal Pierre bongwen beru biak bal me awon ma ini boli kum dano mano toro chep me wilogo donc ino ni mono ikine me ma Aliba chel mi bongwen Pierre bongwen ma chel ma Aliba rio kapi ikala hills mati ikila county ya Moro district ikumal me Uganda ki bot ka beru mo kane pin me Sudan LRA do no te canal Rwam enti ukitwa ma mege ikomwan man
Recording in progress. Recording in
Arranyi
progress.
machero toro tuero to war ikumdano maman chero nyono chiek dek me Geneva Convention maki wachi kineme ma Aliba chel mi abungwen chel kima Aliba reo ki a beach ikaber me kila hills mati kila county mati amor kumbedini nan ma biak me balti kume amor district kumal me Uganda ki bor kaber mo kene me kupiny me Sudan nan ma biak mati balti kumeni ber no commander ma LRA dox no ti kanol rom pa LRA ma eno ti kitwer ma me ngan ma ke maga ma ke lo ganyi saten NS ber ke tek challa choki dawo bikar malaj mano cherkol awon me tam me chwin ikom ngan man NS makum ngat en no ti chek no mer gwari dok ngat en ngan ma biak ma balti ko no mer ngeni man dar man chek gwago.
The assessors advise the court to find the accused guilty, and in agreement with them, the accused is hereby found guilty and convicted of the offense in count 91.
Itama megi jo makonyo kot ki ngol ko chimir ki nong ni mano an ma adoti kume otor chik man
The subjected and abductee was identified as NS to repeated incidents of forceful sexual intercourse, conduct which inflicted severe physical and mental torture or suffering upon that victim, while was aware of the protected status that that victim enjoyed.
ai biak me bal pier po ngwen pier yo amano beru bar me ti gero ko badano ma jero kelo nyono tien chik me dek me Geneva Convention ki wachin ma Aliba chel mi abwen pier abwen mo bichen ma Aliba yo ki abi ka ber me kila hills ma ti kila county amoro district ko mal me Uganda ki bot ko pin me Sudan ikarma ngan ma dot ti ko me ono ti kamanda nyola ti Rome kano LRA uti kitu arma mege ikongama eno maga makilone NS dog berka berkere ter kibat ma ko la awano mater ikone ikinye dong man kum eno merongeni meno kin matoro chef melwan.
As I said, the accused, the assessors advised that he found guilty.
Yes, my lord.
Yeah.
Donc joma konyo kot ngol gumi utama me gini mer kinong ni mano ngan ma adoti kome otoro chef man to bal man kot beno mo ni mano ngan man o bal na pia gwen werio donc mer non fot mo bore bal man.
The last count, it is count 93, where the accused was charged with the offense of rape under the Penal Code Act. That offense was charged in the alternative to the offenses in count 92, 91, and 90, and is hereby dismissed in light of the court's findings in those counts.
Me gikire obero bal me na piara bongwen to ade maki wachi no obero mak tek eto man onodong ki no foto ko ye ki no bala ye piara bongwen we ario piara bongwen no chel piara bo ti dong pe kram no ene dong pot udir man te bae te.
In the result, the verdict of this court is that the accused was found guilty on counts 5, 6, 8, 10, 11, 12, 13, 15, 16, 20, 21, 31, 33, 34, 35, 36, 37, 39, 40, 41, 42, 43, 44, 47, 48, 49, 50, 51, 70, 71, 72, 73, 74, 75, 81, 82, 84, 85, 86, 87, 89, 90, 91, and 92. He's found guilty on 44 of the charged counts.
Donc ineno pa court man bunoni ngan ma doti kume oporta chiek machalo ngan ma balo ibal magi bal nama beach nama bicher nama poro nama para chel nama para rio nama para dek nama para beach nama para bichel nama piera rio nama piera chel nama piera dek chel nama piera dek nama piera dek ngwen nama piera dek beach nama piera dek bichel nama piera dek biro nama piera dek ngwen nama piera ngwen nama piera ngwen chel nama piera ngwen rio nama piera ngwen dek nama piera ngwen ngwen nama piera ngwen biro nama piera ngwen boro nama piera ngwen ngwen nama piera beach nama piera beach chel nama piera biro nama piera biro chel nama piera biro rio nama piera biro dek nama piera biro ngwen nama piera biro beach nama piera boro chel nama piera boro rio nama piera boro ngwen nama piera boro beach nama piera boro bichel nama piera boro biro nama piera boro ngwen nama piera ngwen nama piera ngwen chel idong nama piera ngwen rio magi juju kelo bal mik bal piera ngwen maki noni ngarma adoti kume opore te chiep.
The accused is hereby acquitted on count 2 and 3.
Donc, bal maki pa chen ikwanyo ki kum wi ngarma doti kume bal na machel bal na mario ki bal na badek.
The following counts were dismissed. These are counts 14, 17, 22, 23, 24, 26, 45, 52, 53, 54, 55, 56, 57, 58, 60, 61, 62, 63, 64, 65, 66, 67, 68, 69, 76, 77, 78, 79, 80, 88, and 93. There are 31 counts where the accused are charges.
Bal makitiro chen aye bal jara dek wachel ba mana ye bal na mapara ngwen na mapara piro na mapiare rio na piare dek na piare ngwen na piare bichel na piare ngwen beach na piare beach rio na piare beach dek na piare beach ngwen na piare beach beach na piare beach bichel na piare beach piro na piare beach boro na piare bichel na piare bichel chel na piare bichel dek bel piare bichel rio piare bichel dek piare bichel ngwen piare bichel beach piare bichel biro piare bichel boro piare bichel bung piare biro bichel piare biro biro piare biro boro piare biro ngwen piare boro piare ngwen dek man bi jowen chip bal piare dek chel makot obayo chen ipemero iket iwi ngalma adoti ko.
That is the finding of this court, and you shall be supplied with a detailed judgment.
Mane mok bakot man dong kibi min wu matute kore la chen.
Yes.
My lords, at this moment, coach, for how far we have come. This is the moment we've been waiting for so long. My lords, we intend to make detailed submissions of this court in respect to determination of sentences on each of the counts for which the accused has been found guilty.
Wamero wachine man wa foyo o chairman ngolman mane kare man wa perka porneni don wa bino kare memiu mirbo matut mapago kwa fort mamiro kimi balman ma mo wingar ma doti ko.
My lords, the rules of this court and the sentencing guidelines give details on number of factors and considerations to be made while finding the most proportionate sentence.
Donc chef me code man ki ket mangol woro kere ti nyoro kore jema mo mer kenen makwako nyig balman ki fore ngoma mer mi mo pore ki balmano o moke ne otime.
One that shall be proportionate with the nature of the offenses, the gravity of these offenses, and the culpability. Among other considerations.
Pod matno timo pore malugo kitma balmo time kere kitma kar ma balo time kere manor wata kit ma o moke kere nim court.
My lords, also this court is required to take into considerations not only the law but also the aspirations and values and norms of the people. My lord, people are not only us who are in court, but including victims and communities out there.
Donc, wamero wachinamano ingol makitman pekineno chekeken kineno bena miri kitme guri me ko badano ma lo ma balma kumano pungi mai kinatie joma tilon kini victims ki joma ti wa kuja raya magiti ijar kuja be mer kinen miri mameki.
We are therefore asking for time.
Donc watika lego bikare watika lego bikare wa katwere non ki di kote eni
whenever us prepare
wa mini wakare tikero me yopo foi fort mo pore malu biak me bal mo mo pekakan.
My lords, I will not suggest time. Let me allow my colleagues to make a response. My lord say, my lord, in consultation with my colleagues in the defense, here, we are proposing a period of 1 month.
Malupe ki kupe mo kupe.
My lord, for both of us, we can take 2 weeks. Yes, my lord. How many sites do you have? Yeah. My lords, there are 3 sites. So we propose 2 weeks for each.
Malupe ki gwenye kitame kinwa watamani kimi ki dula chela chabira bria rio kima wati dula der kakani.
My lords, Charles Konya, friends,
And Charles Dalo Choro Konya ki ngal madoti kome.
our colleague Mr. Laka is going to make a brief reply and prayers.
Na wotwa kale balara obimio tamme ki kwache bene malubo mana nyim kodman.
My lords, for the record, Karibalaka
Alaka. Mironoi Dojo and Caleb Alaka.
My lords, we are of the view that the time suggested by the learned deputy DPP will not be enough for the following reasons, my lord.
Amir Miotam Kwacha Nim Kotman ni Shawa Mala Wotwa ma office but DPP okay Nim Kot and Tipotwa Perombe to Mopore Itian Lok Magi.
My lord, when it comes to sentence,
Kao I Mio Food.
we are obliged under the rules, especially Rule 47.
When we're there.
To guide court on as the rule is framed in such a manner that it's good to consider those parameters. We believe for participation of the convicted person, issues of the degree of intent, and the circumstances relating manner, time, and location are issues which we may or we have value on.
Don't want to take up me because time the mano Kao Mopako me Food. Olotie Wang Cho Momia 1 million time to board court. Keep Rom Mangat, my Pierre Balticome, of more Alcome, Geretie, Ego, Twin Mount Antiquette.
My lords, at this stage, you have not yet read the detailed judgment.
I tell an Fupia Wakwano, keep my Maturi.
And we are not in position to effectively address court in view of other standards, like when we had wild issues to do with joint criminal enterprise, whether it's 2 or 1, we do not know whether they were applied in the judgment. So, reading the judgment on our side will be essential, my lords, for us to be in position. Apart from that,
but I want to be better. Miero, catch your coming in Wakare, make one no, but two kid man all in to make it a weapon. Romango, make it you kere, Kino Kidir, Kyo Tepango, Magok, you kere, Mikati, in all man, Kawa Petty Kero, make a manemo for it.
On that point, we do not have a picture of how soon we shall get that judgment.
Donc, kumbe pewa ngeyo karmarom menema kiromi wa pero atera ki ngol man man toti inyim bodo.
In addition, my lord, we're obliged under the law to make submissions of mitigation.
Ikit me check kit ma kot yu kere wan bene mirwan nen jim mo no kilon chalo gin me back for dog ma do be ki go rom me bal rom me fot ma koni bikati nyim kot.
Because my lord, court in the sentencing will take into consideration mitigating factors, aggravating factors, and my lord, because of its peculiarity, a report of the probation officer on the social background of
Taman mano di pierre protect mano ma me gi me be wan kere nyim kori.
it also provides direct the defense to file a mitigation statement on oath, and it also allows the where the defense files a mitigation statement on oath, the prosecution is also entitled to file a response to the mitigation statement.
In Kitmach, Kotman, Tukere, Karmukene Kotman, watching Mano, or one machado, what take a chewy Konganma, adopt or more valley come, near what cho, Dok Mamewa, on your back of Dog Mameka Mano, Mirwa, Ponge, Aqua, Tikamano Time, Karmukene no, be made any mano, Yomukera dot bene, Mir again, go me lock doggy Madara, Makumno Konga, Quan, or an import.
This may entail an outreach.
Any Karmukene, be made any doc lock bot the Tano, in Gantama. Jimmy Mountain,
has other implications, my lord, which are administrative in nature.
Makaram can kill Jim Canamanon, Cherry, Kitme, Kubotich, Mamero tea.
My lord, we shall therefore pray from this honorable court that within the time court will grant us, we are praying for the following, in addition to not opposing the adjournment.
Donc, Kirkibet Koni Kore because you are Tamni, Ubiter Karmaromene, what you call Wachelario, Mama, Amity Corbene, Uti Kere, Okerenime, and a penny what you acquire a lot of money near the D. Gordon.
And my lord, the court orders that the probation officer of Amuru district makes a report on the social background of the conflict.
What I'm here, me or the court where Kichwal Botngan Mador, Matal probation officer, the district Mamoro, Mamero Katiki report Mamegi Bene, Matiro, Lok Komngan Madon Comere, Bal Iwieni.
My lord, we shall also request for an order that Uganda prisons gives a report on the conduct or how the convict has been in all these 17 or 16 years, how his conduct has been, my lord.
Atamo we meto bene order mukena mamero Kichwal Bolu Diro me prison, ma gembe mi report ma megi, ma logo kitma ngan madon ki mo bali wiye, ubero kere I puj kono pikema para pichel nya para piero ma eno pero ichi.
My lord, finally, we seek leave of this honorable court to grant us the defense permission to file mitigation statements on all.
Donc, lego bene court man ni katwere o mi ne wabera gonya me moko kwaj ma me gwanyo lega nyo ba ko dog ma me ko ma ko kumbal ma donc mor kumbedini I nim court man ma kum no wa konge akwaye.
My lord, it's because of these different issues, the immediate availability of the decision, the detailed decision, the need for a report from the probation officer, the need for a report from the prison, and the request or leave for us to have these mitigation statements on all, that we are praying that this time might not be sufficient. However, God can also give us time within which we can accomplish all this. Otherwise, we are much obliged and we are grateful to you, my Lord.
Donc malupe ki koy jeme angwen man wena me waram no report matiro kore ki kore bal ma ke mogo report ma akibot probation officer ma moro ma akibot prison ki kwaj ma mewa me kuonge akwa ma ko no miyo ki me ba ko dog ma megwa watamani kare man manane ki chimoni kar mo kene perwate eto we wego iching court me min watam menen kar ma ko me dugo I court man.
Before we take a decision, can we hear from Victims Council?
Kimir konge win tam ke joma chungpi joma guno awano malupe ki luenman.
Most obliged, my lords, we entirely agree with the submissions
that have been made by counsel for prosecution and the defense with regard to the timelines. But we wish to add that we equally need time so as to make observations as far as sentencing is concerned. And in that regard, my lords, we may also need time to reach out to the victims of crime by way of outreaches. Secondly, my lords, we also need to file with this honorable court the victims' impact assessment reports, especially on those counts which impact on the victims. And lastly, as far as
Councillor Maki, would you please allow for interpretation?
Okay.
Thank you.
One machalo lupilida pa joma balman meloni gurkongi. Wape ki kwe mo ken mo a kipot dulario en pa lukela dot ki joma chumpi ngarma me pa ki kome. En ki bot wabe watamani chuken mo malupe ki it koni foot magbikati. Pigin mo kene man be mirwan bene. Dok matie kin pajo mabal mano gurkongi. Maman bitime malupe kikin maklon won ma wachero kunu kibene mier koro yeni wa wano mi report mamewa makit ma awano man uguru kere kom joma wano chung pikiri maklon victims impact assessment report bene mier kiye wano mi import.
Lastly, my lords, all those applications that we have made on behalf of the victims, we shall need administrative support from the court in order to be able to achieve what we want to achieve on behalf of the victims.
Nung me gikine watiki kwaj mapol mawano remo inyim court man don wabe mitani olo miero court bukati me diokowa we gin mawano kero machalo kwaj mame kwani onyak nige.
Do you have any reply? I don't think so. Okay.
Yeah. My lords, we shall leave it court. We are today, but if the court, then court will the period here. I'll give you that depending on when the judgment will be available.
Don wana be weko man board court wan no tamani kache no gok dong ngol ma tut weng dong tie no gamlo ka bero ka pere wa mi ru ki board court ma court mi tam board wa malo kara ba mi ki dugu ye board man.
My lords, we are also suggesting that maybe we could have a status conference in between before we set the timelines.
Walde ko court benen ka twere ki mina wa kare me bero ki wenye ki lok ikinwa ma mono lo status conference ma futte wa mogo awene ma gwak ko twar dugu yim court man fi lokal.
Okay, the court has listened to your submissions and prayers. That one, you will have the detailed judgment Friday of this week. 2, a status conference will be convened early next week. You will be given the notice and directions, but probably not later than Tuesday of next week. And then 3, following the status conference, directions as far as the submissions and other administrative matters will be made by the court.
John court man malego lokma wono yaro kwachu ki ko mamego ma chien report Banyoro kitman ngole en worgere kore bi o boru kia mapea kia big en lokaro me ario kwaj mamewo bi kwenye kilo maklon status conference eni bene ke bi yobo isapet mabino maka twa mi ro kat chiario me sapit mabino ka dong je mario e me chiro ngatama je mo kene wen malu kwa ma megu ki nge mo kene dong unu twero nongone ma kore be mi one boto.
Okay, this court thanks all of you for your industry up to this point, and this matter is adjourned after the status conference.
Court dong for you want to jo court man ni why status conference ka chaka ma bibiru ti yam.
So, Actually, for your greetings to everyone. Let me use English because I believe some people are listening or are following
Recording stopped.
actually in English language. Other people doesn't understand actually language. So, what you've been following was the issue of the court case for Kwoyelo, and that is what you have heard about. You can replay the link. We have been having issues with connection with our technical support team, but then at least it has been fairly broadcasted, so you can check it again. Any other details will follow. Thank you very much, and I believe if you have subscribed to this channel, you will always get update of the current affairs that concerns Uganda and those that also concerns the Acholi people. Thank you very much. Nice time, and we'll see you in the next one.